why is that so fucked up? Oh, that's why. Mm. So chat got kind of crazy this morning, and I've been kind of fielding complaints about it over lunch. I didn't get as much done as I wanted to, but I got some stuff done at least. Um, when the trial's going on, I am definitely going to be restricting the chat to matters related to this case. I'm not trying to platform ideological arguments or back and forths because we know that there are people here who identify as leftists and right wing in the chat, and I don't want to be dealing with arguments and fights over this kind of stuff. So if you're suddenly not able to post, it is just a timeout for a few minutes, and you come back, as long as you don't keep doing that, I'm not going to kick people permanently from the chat. And I mean, yeah, if they're talking about Mr. Swinney's second chair attorney, I mean, she's not. You know, I don't think she had much to do with what happened here. Um, yeah, I suspect they tried to coach him as best they could, but so that being all said, at this point we are expecting the attorneys and the judge to be back any time now. Um, there was statements made by Mr. Vasquez about evidence that was previously ruled inadmissible that now, because Mr. Swinney has taken the stand and testified, extensively, um, that they want to revisit and try to get some of the testimony included, or some of the evidence included now, which I think just made a difficult situation for the defense that much harder. And, nobody twisted Mr. Swinney's arm to make him testify. Um, as far as donations, if you can and you feel comfortable doing it, down in the video description, there's a link tree that takes you to um, it takes you to a list of all my links. I do have Cash App, Venmo. But again, I mean, trying to I'm not trying to do this to make money. Anything that I get just goes into continuing to do this kind of work. At this point, probably a decent chunk of it will be getting sunk into getting audio records from the trial, so that we have like the official audio and uh, some of the other hearings. I know I've been mentioning a lot about what happened last Friday when they went over evidence, but I didn't have the audio. I can request that, and I have to pay about $10 to the court to get a day worth of audio. So, and yeah, James, I think the lesson from this morning very much is, if someone gives you the right to remain silent, take it. Thanks, Kat. Yeah, I've been hearing that, and I can't think of any way that it would benefit them. It's hard to move for a mistrial when it's your side that has made the errors that could cause a mistrial. Um, and the same thing with an appeal. You'd have to be able to prove that the jury was, unduly biased, or some error in law was made by the judge or the prosecutor. But to say that we let our witness on the stand and he testified to everything is not going to go over well at an appellate level. I mean, I will say I could see somebody making the claim of secret Antifa, but then that argument falls on its face anyway, because even at my understanding, even when you're on the stand, you can take the Fifth Amendment on particular questions. Um, and your lawyer can't force you to testify in a criminal trial. So this is all done with Mr. Swinney's full-throated endorsement. As far as the cat, no. I only got a chance to make one call. I called the county shelter. They haven't seen anything, but they suggested that the county has a website where I basically put up a lost cat ad, and um, it'll help people get in touch with me if they find her. There's a few other options I can look at. I just, with everything going on now, yeah, they actually, as far as WebEx being up, they actually never stopped the stream from when they went to lunch. So, um, it's just been up on my end that whole time. Hmm. Oh, I have a fly around me. There might be some aggressive clapping. I apologize in advance if that happens. Well, the microphone's about 2 feet away, and me to you is well, me to YouTube to you is probably many, many miles, which is more than a certain someone gave before shooting. So, now it does dawn on me. I remembered this when this first happened, and I didn't say anything then, but I just remembered again. Yesterday, when the jury left, there were questions about if Mr. Swinney was going to testify, and it sounded like at that point they didn't know. So, if I was a fly on the wall, I almost wonder if maybe he didn't get a phone call last night and hear that from outside his case is looking horrible. Uh, not the Bundys.
Yeah, I did. Hang on, let me grab them.
Sound. I'm muting my mic.
I keep paperwork in semi-orderly stack.
Did you send them to me as a file, Nate? Oh, Mega's got them.
That's why I took them. All right. States one.
States one, yes, Your Honor.
Can I look over your shoulder? My States one page just went away, so I can just.
You also project them if would that be easier?
Okay.
Okay, why don't we just project them up and then everyone can see them?
I mean, yeah, I guess.
Actually, let me, that's not the right version.
So, you're right. Defendant testified, and I think there were several points in his testimony during which he says that things such as that they were going to follow the rules and it was going to be a peaceful rally, and that, again, didn't go there looking for violence. He hoped for a peaceful flag wave. He described that he was protecting cities and his anger at the people of looting and destroying cities. Yeah, and at one point, I think the exact quote was that he would be tickled to death if no one else showed up. But those are in direct contrast to what we see here. And he also, throughout his testimony, he puts forth this position or this kind of theory of the way that he talked about, that basically he just was there to support and act as security was another term he used, that these were just, peaceful flag wavers, and not, essentially he had zero intentions of coming to the city to engage in any violent acts.
How did he not open the door to States Exhibit 1?
Well, I don't. I mean, I don't know, I feel like I'm over on this when it comes to many of these arguments. But his testimony was, I would love it if nobody came, but I expect people are gonna be there.
Mm-hmm. That's not all he said. I mean, right? Like, that's one, like, if the door is open 12 inches, that's 1 inch of the 12 inches that the door has been opened. Do you understand what I'm saying?
Yes, I understand.
Okay. So, anything else as to the other 11 inches?
Sorry?
Anything else as to the other 11 inches?
I just don't, I think it's a mischaracterization of what he said. I mean, this is what Your Honor ruled about this one before was this is remote in time and it is about a completely different event.
Different city, Chaz, Harris, or Seattle. I think Chaz is Seattle, but your client did testify that he had been going around in the months leading up to this to all kinds of places. So I mean, you know, I don't like that bell's already rung.
But why is it relevant of having another statement we went to Seattle? I mean,
I mean, if you want them to redact, we all got our Facebook accounts disabled because we had a flag right around Chaz on the 4th of July. I imagine that's a relatively easy thing to redact.
Again, though, you're
yeah, we got 3 Chaz terrorists arrested Saturday. Help us get the message out. I mean, you seem to think it's obvious. I seem to think it's obvious.
Right. So I think, I know we talked about Facebook at some point, but I don't think that's really relevant. So take out, please redact, we all got our Facebook accounts disabled because we had a flag wave around Chaz on the 4th of July. And then take out the last 3 sentences. We got 3 Chaz terrorists arrested Saturday. Help us add to that number, please echo.
I would like to keep in the one sentence before it that says, please echo.
Yeah. Right. So he says, please echo.
Well,
Yes.
I know. I'll take out the last echo.
All right.
And I guess what I heard is, but why is that now? What is it now relevant to the case for?
Well,
It's impeachment.
Impeachment of him. It's rebuttal. What he's saying. It's, you know, it is directly in contrast to his testimony that he didn't go there looking for violence. He hoped for a peaceful flag wave.
And I'll just respond the same way that Mr. Vasquez presented these things, is you have to look at the totality of the message that he testified to on direct, which was, a win for me is no violence, but I prepare for people to come and interrupt.
Yeah, but I don't think that, I mean, yes, I think that's what he said, and I think this is impeachment of that.
How so?
We are the absolute tip of the spear as far as the right's answer to the left's violence. Characterizing yourself as the tip of the spear is more of an offensive act than a defensive act.
I understand.
Okay. States 2 is already in. States, what else are you trying to get in?
I don't know if States 2 is in. Oh, is it?
I thought it was.
My apologies.
Oh, maybe not. My notes are.
Let me just go back and.
I mean, we're also going to have to talk about the limiting instruction.
Anyway, I think
because
State 2, quite honestly, is the same. I mean, it says basically the same stuff as State 1. So for the purposes of impeachment, let's try to not be overly cumulative.
But you're right. These are 2 posts, and it adds that this is the last crusade. Follow us. I mean, this is. They need to be taken together to have that meaning. So I mean, those 2 come together. That's why this one's here. It adds to that very point which the court was making, which is he believes he's on this crusade. He's not out there to just do a peaceful flag wave. And that's what's going to come through in the impeachment with multiples of these, is that he is saying that, and it builds through time. It's one that, again, the state's not like hundreds of posts here. I mean, which, you know, he may well have done. I don't have access to Parler anymore because they shut Parler down. But the reality is that the state's not piling on massive amounts.
All right, states you can come in as impeachment. You started to say something about a limited instruction.
Yeah, we should continue to keep, because I'm sure somebody's been keeping track of, because the state asserted intent, motive, plan. The court needs to instruct on every single one of these with regard to, so now, is the first one coming in intent, motive, plan, or is it clear only coming in as impeach?
It's coming in as impeachment.
Okay. Same with second?
Yeah.
So, I guess they'll need to be instructed that those aren't coming in for their truth. Right, and there's the problem.
But they should come in for that.
Impeachment never comes in for
So
the
if I
truth,
may finish,
unless it was under oath.
so, so it should come in for intent as well. That he's opened the door to what his intent was, because he has said on the record and testified, my intent was to go and have a peaceful flag wave. We didn't really do that. Yes, it impeaches it, but it also goes to that very intent of what he was doing.
When you say one thing.
Yeah, I just want to make sure. I completely lost my mind. What number is impeachment?
602?
Thank you.
Is that right?
That sounds about right.
609?
It's in there.
It's bias and interest is 609-1. But that's a bias and interest. That's not prior inconsistent statement. Prior inconsistent statement is just going to be hearsay. 800 something. $801.
Sorry, what'd you say?
I thought maybe 801. I'm going to go to the computer and see if I can get it. 613. So it looks like they don't even get the host in if he acknowledges that he wrote that before. Looking at page 597 of the 7th edition Kirkpatrick.
Senor, this would be a statement of a party opponent, so it wouldn't be hearsay.
It's extrinsic evidence of the prior inconsistent statement is not admissible if the person owns up to it when you ask them about it.
But so it's being offered as substantive evidence.
The prior inconsistent statement. Oh, it says does not per se require exclusion. When you get down there, it's a disputed topic, and the danger is that the jury will consider the prior inconsistent statement as substantive evidence despite an instruction not to do so.
Oh my gosh.
If this is all, by the way, if this is all going to the exceptions to the self-defense instructions, maybe we should just start there, because if he gets to go in and say now self-defense exceptions, then what he has done is he has turned this, turned all of these statements that came in for 4043 rules into propensity evidence by saying that he acted in accordance with that when he went down there, as opposed to it merely being his motive for doing so.
What's your theory for admissibility other than impeachment, Mr. Vasquez?
These certainly indicate a plan, intent, and motive. Again, I understand that the court, when we went through these, we had these arguments before, and the court specifically said his testimony could definitely change that, because he came in and testified that basically it wasn't his plan, intent, or motive to engage in a crusade or to gather up members of a militia to come down and do that. I mean, he just takes his direct testimony went in the exact opposite direction of what he's stating here.
And I think there's a real problem here that I sought to get the parlor post that I got in through Mr. Swinney, where in all capital letters he said, it is our goal for a peaceful flag wave. I tried to get in that through Combs, who did the online.
Yeah, it was hearsay.
The state objected to that.
Because it was hearsay when you tried to get it in with phone.
So now the consistency of the prior statement depends on when it's offered. Because I'm not
trying to be rude to you. I don't even understand what you're arguing right now.
Well, if the parlor post that we put in had been admitted through Braun, then we would have had a prior consistent statement. Our goal is a peaceful flag wave. Now all of a sudden.
But you brought that in on your direct.
I sure did, but because it wasn't brought in, now there's prior consistent. Sorry, they're calling things other than that. I've tied myself around the axle here. Let's just move on.
I mean, I'm just not following you around your twist. So, but I am, perhaps wrongly, twisted around the axle of impeachment as substantive evidence. Do you understand what I'm saying? And certainly 609 seems to suggest, no, not 609, that's the wrong one.
607?
613. I mean, if you look at the very bottom of page 595 of Kirkpatrick's 7th edition, the last paragraph, the fact that a witness gives inconsistent testimony goes only to its credibility and does not affect the sufficiency of the testimony to support a jury verdict or destroy its probative force as a matter of law.
I don't think that's on point with this, Your Honor. I think the court should look more at the impeachment by contradictory evidence.
Where is that?
511.
Page 511.
Sorry, page.
Yeah, I knew.
Oh, page 511.
Yes, this is more of a relevant section. Now let's see what happens. Except yeah, no, they're right. State's right. Under Rule 607.
What's the, what part of Kirkpatrick are you looking at?
At page 511. I mean, it's certainly a non-collateral matter, right? These questions of self-defense and his intent and purpose for going.
Well, that's why we get back in the weeds of other acts evidence, because those other acts cannot be used to carve out the other acts where they. I haven't heard Your Honor recently say, well, I mean, sure, you're going to find that it's for intent. I do note as well, though, that testimony can only be impeached by contradiction when it is sufficiently precise to constitute a clear statement of fact that can be rebutted. So what we have here is rhetorical stuff. We're the tip of the spear. That's not a clear statement of fact. That's rhetoric.
His thing is, he said, I'd be tickled to death if no one showed up to oppose his group. That is about as direct contradiction of that as it can be. This is not rhetorical rhetoric. It is much in the exact opposition, and particularly when Redwood State's Exhibit 2, which was posted on the same day.
I mean, here's the deal. When we went through all of this pre-trial, we talked about whether or not some more of this would come in if he opened the door. I mean, he said a lot of stuff in direct exam today that painted his intention as only security, only wanting to protect people's rights to peacefully protest, and this does directly contradict that.
It's a clear statement of fact. You're finding that as a clear statement of fact.
Yes.
Okay.
But I'm not gonna, it's not all coming in. So that's, again,
I
that's gotta
understand.
be redacted.
Yep. I have the redacted portions highlighted so that I will do that in a very
All right.
quick fashion.
What else do you want in that isn't in already?
States Exhibit 3 and 4.
All right. 3 can come in without the picture.
Okay?
Hold on, where's 3? For what is it coming in for?
Impeachment and also to show his intent.
So we'll need a jury instruction relating to intent with that first. You may use this evidence only for this. You may not use it for anything.
All right, so let's talk about I'm gonna just give one instruction at the top of cross-examination. Some additional exhibits are coming in.
Okay.
Members of the jury. The state will be using additional exhibits during its cross. What do you want it? What did you say?
Well, I mean, if we're talking about number 3 at this point, I mean, I understand Your Honor is going to admit it. I am objecting to each sentence individually. For example, if you don't know who I am, search Alan Swinney in Google. That's certainly a collateral matter. And so to the extent that there's findings for each of those individual sentences, if there's a disparity in why those sentences come in, then we need to further break them up and instruct on this is for intent, this is for motive.
I'm not going to do that.
But if it's all coming in for intent, if that's your ruling, then you can say this is coming in for his intent. To do what? I don't know. I still haven't been able to.
It goes to the intent, motive, and his plan.
To do what?
So his plan is to gather up a militia of people. We're literally fighting the militant wing. We need your help. So that's the plan.
Members of the jury, the state will be using additional exhibits during its cross-examination of Mr. Swinney. The purpose of these exhibits is to demonstrate Mr. Swinney's intent, motive, and plan on the dates in question.
I would just rather not have that instruction.
All right, then I won't say anything. All right, so 3's coming in without the picture.
I object to that instruction.
Okay.
And think it's worse to go in. So. See. Because his intent with regard to what? To go to the square? I mean.
His intent is not to go just to peacefully wave a flag in support of the police and or act as security for those who are.
Let's ask for a limiting instruction at the end.
All right.
Okay.
States 4 is the last exhibit the state wants to get in.
May I just take one look? There's also states 18. Those are the 4 and 18 are the last 2.
How is the first sentence relevant? How is the door been opened with regard to the first sentence?
I'm sorry.
Are we on 4 or 18?
Yes,
I'm looking at 4.
Okay.
So I don't necessarily think we need to go sentence by sentence, but Your Honor, so he certainly has already talked about going to other towns, other places. He also presented testimony that essentially he was just kind of showed up to be security, where this is in direct contradiction, that it shows he's saying things like, my plan is to hit towns and recruit, then we go in together to Portland. He tries to put himself out as this kind of just, I'm just there casually versus this.
Although, on this date, does he not say basically like he was staying at a Motel 6 in Southeast Portland, he got up and they came downtown. So I think States 4 is admissible at the start of flag waves are tons of fun and there are just enough libtards around to make it even more entertaining. If you have people from Oregon following, please echo this post. If all this stuff has been pissing you off, here's your chance to do something. Even if you can't be here yourself, echoing this post will boost our numbers. This group is actively fighting the left, not figuratively. We get toe-to-toe with these people. That part can come in. But not the last two sentences. I mean, I guess if you really wanted the very, like, I don't want to this date I've helped to get 83 of these clowns arrested, 3 by way of hospital and 5 off to prison.
Yes, I'll take out the to date part where it and then ends off to prison.
Okay.
Chop that off.
And we're cutting out up the beginning through the sentence that starts flag waves.
Yes.
But we still object to the entire thing.
Yeah. For example, I'm not sure.
I assumed as much.
I just want.
But for the record, I understand.
And we're objecting to each individual sentence.
Yeah. Okay. I still don't like 18. I'm not going to let you do 18.
Okay.
What was 18?
The football and military, perfect combination of the two. All right. We ready?
I'm gonna need just a moment to make those additions. I'm sorry.
That's okay.
It won't take me too long.
I'm going to use the restroom. I'll be back before he's done.
I will.
Take us off the screen.
Okay.
Yeah.
I'll be here when you're back.
I'm assuming. They've been pretty on time every time, right? We don't really have a struggle.
Maybe warn them. I want to get you in a minute.
Yeah, and say, like,
I won't be taking that.
yes, because this has taken longer. Yeah.
Isn't telling me how it is working correctly. Is that right, Reed?
Say that again?
You're making sure that on the top screen it is doing what?
The top screen is not projected, but it will be the same.
This one
It is, but if you click, it's like email, but nothing.
Okay.
Showing in details. For all of us.
Yes. Out. This one was no picture, correct?
Mm-hmm.
How good are you at divided attention, Mr. Vasquez?
Decent. How about that?
So if you're impeaching Mr. Swinney, does this mean the state's also going to want witness false in part?
Yes, sir.
All right. Well, then there doesn't have to be a fight about witness false in part.
Yeah, that's true, it just comes in. It doesn't go to a particular
I'm not going to say who's,
which witness.
I don't say which witness is false.
For the goose. What did I say? Good.
I mean, do you want to be heard? Like, you look very,
I object.
so now you're withdrawing your request
I
for
mean-
witness false in part?
An inconsistent statement is not per se a lie or a falsity.
Right. That's true.
Yeah. So I object to witness false in part coming in with regard to Mr. Smith.
Well, it doesn't say who it's in regard to. I'm either going to give it or I'm not going to give it. And the parties are free to argue it or not argue it.
Fair enough.
So are you withdrawing it or do you want it?
I mean, our request ought to have been for specifically which witness there was evidence to support a falsity.
I don't think Payne suggests that a witness, in fact, I feel like that would be the court commenting on the credibility of a particular witness. I don't think that's an appropriate request.
Understood.
Okay, is that the correct thing?
Yes.
So because again, like if we can decide this before we bring the jury in and I send you guys the jury instructions, like maybe things go faster. I don't know. I mean, at this point, I feel like there's no way we're getting done today. I don't share Mr. Vasquez's optimism.
I think Mr. Vasquez is probably closing on Monday.
Well, that was not
Good coffee.
I wish I spoke lawyer.
Go. There we go.
Interesting.
Right? Let me take a look.
So this is how we edited that.
Okay. 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 And we'll just say that they are offered and received at this time over the defense objection that has already been stated on the record. Okay?
Thank you.
I guess, is there some tactical reason you would want me to say they're received over the state's, or over the defense objection? So the jury knows you don't like it, or do you not want me to say that?
Oh, no, just go ahead and put them in.
All right, get the jury?
I mean,
I maintain my foundational objection.
Also fair.
correct, yeah. But,
Do
We want to put him back on the stand before they get in here.
That's fine.
like we talked about.
Where?
I got it.
What is it? Oh.
You said you wanted that in.
Okay. Go ahead and have a seat, I think.
Yeah, I'm fine if he says, we do rise for the
Stand when
jury
the jury
technically.
comes in, but
It probably feels good to stand.
Huh?
I imagine it feels good to stand. Been sitting all week.
Yeah, I mean,
Are you still thinking about the other thing?
no, I mean. I've already made that objection.
Just wanted to-
Thank you.
I got you.
Welcome back from lunch. I hope those of you that went outside enjoyed the sunshine that I ordered up for you. Mr. Swinney is still under oath. You may have a seat back in the chair, Mr. Swinney, and Mr. Vasquez, you may begin your cross-examination.
Good afternoon, Mr. Swinney.
Good afternoon.
Earlier you testified you're from Texas, correct?
Correct.
Is that Midland, Texas?
I'm actually from a place called Liberty. It's in South Texas. That's where I was born, but I've lived in Midland, Big Spring, Odessa, Houston, Dallas. I've lived all over Texas.
When's the last time you lived in Texas?
Midland. That would be the last time.
Yeah, sorry, like,
Probably it was 2018.
and then you testified that you travel around the country to a few different times to go to these rallies. Is that right?
That's correct.
Places like Providence, Rhode Island,
Mm-hmm.
some other cities around the entire country. Is that fair to say?
Yes.
And you said that essentially there you were engaged in these events. Were you confronting Antifa at those events?
Yes. Not all of them. Most of them.
Okay. Now, you testified earlier about that August 15th event,
Right.
and that during the start of it, you alleged that someone punched Mr. Andrew Duncan. Is that correct?
That's correct.
Is a friend of yours correct?
He is.
And that you maced that person in response. Is that correct?
Yes.
But you don't have any video of this alleged punch. That's not in the evidence here today, is it?
Objection.
I can rephrase the question.
Okay.
Is there any video in evidence here in this courtroom that shows that punch and then your subsequent macing?
Same objection.
Sustained.
Do we see that punch on Mr. James Britton's video?
Objection. Same objection.
Overruled.
Not on his video. There's none of the videos that's in evidence. Is that on?
Well, let's get a little bit to then who the, this alleged puncher, is this a guy that, was this Mr. Britton?
No.
So someone completely different, is that correct?
Yes.
And after you maced him, did he leave the area?
He left to wash his face off, and then he came back and admitted to throwing a punch at him, and then he wandered off again. And
So when you left the Justice Center, started your procession back to the parking lot, was he following you then?
the one that hit Andrew Duncan,
Allegedly, yes.
allegedly, no.
In fact, in your testimony, you never mentioned him again throughout that day on August 15th. Is that correct?
Correct.
So is it fair to say then that that alleged threat from whoever that was gone and done once you left the Justice Center, correct?
Correct.
And you would agree then that on your route, walking through downtown Portland, when you got kind of around the corner, you had another incident where you sprayed some mace in the air. I think you talked with Mr. Westover for a time about that. Is that correct?
Correct.
So you're spraying some mace and you pushed a guy who was holding a sign. Is that correct?
Right.
And you would agree he had two hands on a sign and I think it said maybe Black Lives Matter on it. Is that correct?
Sometimes he had two hands on it. Sometimes he had one hand on it while he was waving for other people to move forward.
But he was holding a sign, correct?
Mhm.
He wasn't holding a weapon, correct?
Correct.
He didn't punch you, correct?
That's correct.
He didn't verbally threaten you, correct?
He was agitating, but no, he didn't make any verbal threats that I can.
He was an agitator.
Yes.
That's a term, we'll use your term, he's an agitator. So then, let's move a little further down. You walk from 2nd Avenue, correct, all the way up to 4th Avenue. So you're about 2 city blocks, makes sense, right?
We retreated that far, yeah. We walked in our retreat, yes.
You use the term retreat, I say walk, but you're on the sidewalk in a walking pace, is that correct?
Leaving.
Yeah. Were you running?
I'm too old to run. Hurts my legs.
So then can we agree you were walking away?
Yes.
Okay. So now, you're walking along and you go 2 blocks until you pick a spot where you decide to stop and then confront some people that are walking behind you. Is that correct?
Yes.
And when you do that, you shoot a man in the stomach. Is that correct?
That's correct.
And we saw on the video that that man, he was holding a camera. Is that correct?
Yes.
And he wasn't holding a weapon. Correct?
Right.
He didn't punch you. Correct?
That's correct.
He didn't touch you. Correct?
No, he didn't.
And then shortly after that, and perhaps Mr. Schweitzer, if we could see State's Exhibit 30. So shortly after you shoot the one man in the stomach, there's another, in your terms, agitator. Is that correct?
This person just came on scene. They're. I'm trying to make a buffer, and they're trying to. They're coming close. They're moving in.
Would you agree the person on screen is smiling?
I don't think it's smiling so much as, you know, you call it smiling. It's not a smile.
Okay.
He's not smiling at me.
Not a smile. Would you agree that person didn't have any weapons on them that you could see visibly?
I don't know what he had on him. He just popped out of the side of the.
Do you see them carry? Is that person brandishing any weapons towards you?
No, his proximity is my concern.
So you felt that that person was too close, and that's why you sprayed.
I feel like they were all coming too close, all of them.
this individual person you felt was a threat, so you sprayed this person in the face with bear mace. Is that correct?
At this point, I've walked about 4 blocks away from them, and he's still right next to me.
So did this person punch you?
No,
Did this person verbally threaten you at any time while standing right there?
no,
Okay. And this person didn't display a weapon, correct?
this one didn't.
Okay. Now, you would agree, immediately after you sprayed this person with bear mace, a second person walked forward. Is that correct? Now, and let's back up. Bear mace, you testified that's what you had that day.
Yes,
That's what you sprayed that person with, correct?
right.
And it's painful to be sprayed with bear mace. Is that correct?
That mace actually has less capsaicin in it than regular mace does, but it just comes out at a larger volume.
So your testimony is bear mace is not painful?
No, it's painful.
Okay, so let me ask that question again. Is bear mace painful?
Yes,
And it causes great irritation of the eyes, the nose, the mouth. Is that correct?
right.
It can incapacitate someone for a period of time. Is that correct?
Yes,
And you intentionally sprayed that person in the face with bear mace. Is that correct?
that's where it's most effective.
Yeah. So in other words, it wasn't an accident. It wasn't like you were just kind of spraying around. You pointed it right at that person's face and sprayed it right in her face.
I wanted that group to stay away from our group.
That wasn't the question, Mr. Swinney. Did you intentionally spray that person in the face?
Yes, I did.
Okay, thank you. Now, let's move to State's Exhibit 32, please. Do you recognize this exhibit, this scene right here?
Yes.
And this person, what's this person, what do you believe this person's holding in his hand?
It's
Can I ask a question of the objection?
Yes.
Well, I suppose I'll object to that question based on vagueness. I don't know if he's asking, what do you think right now, looking at a picture this person is holding in their hand, or what did you think at the time on the street that
I'll
person
rephrase it.
Okay.
Do you see the person standing in that picture?
I do.
Would you agree he's holding a phone-like camera in his hand?
In one hand.
Yep. And would you agree you shot him in the head area with the paintball gun?
No, I shot him in the mask area.
You and I will disagree about that,
Okay.
but would you agree in the area of his head that you shot him with the paintball gun?
Yes.
Okay. Did this man threaten you with a weapon?
I don't know what he's got in his other hand.
But so you don't know. So his hand could be completely empty. Is that correct?
I know I want their group to stay away from our group because our group's already been attacked by.
I understand you've told the jury that, but I want to know with this particular man, did you think that he had a weapon?
No, I don't. No.
Okay. And he didn't punch you. Is that correct?
No, he didn't punch me.
He didn't even touch you. Is that correct?
He meant to come inside our group.
So I'm going to repeat the question. He did not touch you. Is that correct?
No, he didn't. I didn't
Okay.
give him a chance to get close
Okay.
to me.
Now, you talked quite a bit about the young black man with the white shirt, correct, in your testimony?
Yes.
We can bring up a video or picture if you need.
I think I know you with the mask on. So
Yeah, he had goggles. I think we'll disagree on that point, but
okay.
he had goggles. So this one you talked about, and we can see him in State's Exhibit 33 there on the edge. Is that correct?
Uh-huh.
And this person never touched you. Is that correct?
No, he was coming at me though. No, he didn't touch me. The object. I'm trying to not let them touch me. That's what,
I know, I'm trying to ask you the questions. Did he touch you?
no.
Okay. And then he didn't, certainly if he didn't touch you, he didn't punch you, correct?
Not me. He made contact with somebody else in our group.
I think we already established you didn't actually see that. Is that correct?
My group talked to each other. We talk to each other all the time.
In that little bit of space, you communicate all the way around there, all that information.
He's aggressive towards our group. Yes.
Okay, you felt he was an agitator. Is that correct?
This one's more aggressive. It's not vocal. He's just aggressive. He's acting like he's.
This is a clapping, right? Is that correct? I mean, he clapped. You heard him clap.
No, he's sneaking down the side of the wall and he's moving up quickly behind people, ducking, and he's
Is he trying to confront you?
Looks like it.
Okay. And you had, in the time sequence, you had previously maced one person and shot two people with paintball guns. Is that correct?
People with the asps and yeah.
We're talking about on 4th Avenue as well. So maybe we should add a couple more. You shot a few more people prior to that. Is that correct?
A few more. No, I think the first shot was at the one guy's belly, and then
Okay, so shot the guy in the stomach.
And then the guy with the mask, I got him.
Guy in the mask.
And then when they started coming out with asps.
Okay, that one, and then you shot a few more other times, and you also sprayed the person in the face with mace. Correct? All of that occurred before this.
That's correct.
Now, Mr. Britton is in this picture as well. Would you agree he's wearing flip-flops?
He's not dressed for battle, if that's where we're headed with it. Right. Yeah, he's
not dressed for battle.
Yeah, he's not.
But he's an agitator. Would you agree? Under your definition of agitator?
Yeah.
Okay. And he had certainly told you to leave. Is that correct? Go away?
About 5 blocks. Yeah, he's following me.
Okay. And he even made some statements about that he would see you in court. Is that correct?
I don't know if I heard those at the time, but
you were worried about how close he was when he's yelling these things, and you didn't hear him yelling
he's
back?
yelling a lot of things.
Okay.
Constantly.
Did you hear him yell at you right before this photo, right before this still frame, that he would see you in court?
I think at that time I was more worried about the guy behind him than him.
Why don't we pull up that clip? And you agree, you previously told him that you wanted to shoot him with the paintball gun, referring to Mr. Britton, correct?
He said, you want to shoot me with that thing, don't you? And I said, I kind of do.
So I want to just, before we play, this is captured in State's Exhibit. Actually, I have the number right here. Just so the record's clear, we're going to be talking about State's Exhibit 52. So where it's paused right now, would you agree your back is turned? So in other words, the camera, you're walking forward, you're not even looking behind you. Is that correct?
I have to look forward sometimes, but I'm always looking back over my shoulder,
Okay.
always.
Would you agree at this point, when it's where it's frozen right here, that you're not looking backwards? Is that correct?
It doesn't look like I am.
Okay. Are we able to play that from there?
Me? You gonna shoot me with your paintball gun? Fine, do it. I'm not threatening you at all. So if you want to beat me and you want to assault me, I'll see you in court, buddy.
I'll see you in court, buddy.
Right. Just shoot that right on my head.
And so it's there when he says, I'll see you in court when you turn around, correct?
I didn't hear any of that while that was going on, no.
Okay. But you heard him sneaking up behind you?
I didn't hear him, I saw him.
Okay. do you have like reflector mirrors on the helmet that you're able to see behind you, or did you turn your head when it wasn't, the camera wasn't looking?
If you rewind it a little bit, you can see where I start turning my head, and you can.
We'll move on. You would agree that you had a paintball gun that day, is that correct?
Yes.
Okay. Would you agree that it hurts extremely bad to be shot in the face with a paintball gun without any protective gear?
You know, I've never been shot in the face with one, but I can imagine it does. I can imagine.
So you would agree that? And you would agree that could cause a serious injury to someone's eyeball or eye face area?
Mm-hmm.
Objection. Calls for
Overruled.
speculation.
Overruled.
You testified a lot about, like, that you use the paintball gun for various things, you use mace for various things. What do you use the big knife for?
If somebody pulls out a big knife.
Okay. And then you had that, how long have you had that riot helmet for?
I got that probably in, I think it was around 2016.
And does it, and you already said the helmet doesn't have anything reflective on it, so it doesn't necessarily help your vision. Is that correct?
No.
Okay. How about the padding? How long have you had the padding for?
That padding I got probably say maybe 6 or 8 months before that video that you just watched.
And you weren't the only person that was armed in your group that day. Is that correct?
Correct.
There were more people with paintball guns and mace, correct?
Correct.
And one guy had like a big, like, wooden shield that was maybe 4 feet tall.
Right.
And he also was carrying a sword about 5 feet long, maybe. You see that?
You know, I never saw it, but I hear he had it, but I never noticed. I don't know if it was like I don't know. But I know he had it. Yeah, I know he had it
Okay.
there.
No, yeah. Can we go to State's Exhibit 41? Are you able to see that okay?
Mm-hmm.
Is that how you looked on that day?
Yes.
Here, I'm going to need a sidebar.
Okay, come on outside.
Thanks.
Oh, I think that one question just impeached that whole other witness. The one who, looking at this exact same photo, said that she didn't see him with any of the gear, the bear spray, the paintball gun, the knife. That, if I'm following this right.
All right, you may continue, Mr. Boston.
Thank you. Had an opportunity to look at that photograph, is that correct?
I have.
Okay. That's how you looked on August the 22nd, 2020, is that correct?
That's correct.
In fact, I think you may have even posted that photo, is that correct?
I obviously didn't take that picture, but I don't, it's been a while since I've posted stuff. I can't
Okay.
remember if I posted.
All right, but it's a fair and accurate representation of how you looked that day, correct?
Yes.
And you talked about how you were dressed similar, but you had mentioned the one other addition you had was the revolver, correct?
Correct.
Okay. And you also made some upgrades to your paintball gun, is that correct?
Oh, the laser, is that what you're talking about?
Yes, sir.
Yes, I think I put that, I think that was something I put on, but since the other rally before it, or the one on the 15th.
Yes.
So you put a laser sight on the side of the paintball gun. Is that am I getting that right?
That's right.
And had you sighted in the paintball gun to make sure it worked?
Roughly on a tree.
Sure. You put the laser on the tree, fired some rounds, made sure it was hitting on target.
Right.
Fair to say?
Yeah.
How far away did you sight that into?
Yes. Maybe 20 feet,
20 feet?
25 feet.
I'm standing about
It's about right where the tree was.
right where the tree was. Okay. Were you able to hit on target with it okay?
I was.
Okay. Let's be clear about the things that you had that day. We're going to talk about that paintball gun here in a second, but are you able to see that on the screen?
Mm-hmm.
And then you had the knife, is that correct?
Correct.
And this is the revolver, correct?
Correct.
And your flagpole, is that your flagpole?
Mm-hmm.
Okay. Let's talk a little bit about that flagpole. On that flagpole, as you call it, is the American flag you have attached on there, is it about the sheet size of this sheet of paper? This is a standard kind of white piece of paper.
Right.
Is that about the size of the American flag you had on there?
Might have even been a little smaller than that.
All right. And is it fair to say you got some pretty big hands, Mr. Swinney?
Uh-huh.
And but you're able to wrap them around that particular flagpole, correct?
Right.
How thick would you say that flagpole is?
Oh, 3/4 inch.
3/4 inch wood. So for that size flag, you don't really need that large of a hole. Is that correct?
That pole serves multiple purposes.
Tell us about those purposes.
It's one of the, it serves a purpose between when the paintball gun might not be quite the item to use, right? It's a stick. I got that from being hit with one in Providence, Rhode Island. I got hit in the back, and then I got hit with a bike lock, and it broke one of my ribs in my back. And
so that stick you could use to hit with people, right?
yeah, I can use it to block their hits with it.
But you can also use it to hit people with, correct?
Yes.
Okay. And that big padding, what is that? What is that from?
It's
The yellow writing is what I'm referring to.
it's like for kickboxing practice, but it works really well for blocking rocks and stuff.
Okay. And it allows you to also fire a paintball gun kind of and use it as a shield while you're firing the paintball gun. Is that true as well?
It helps, yeah, it did serve that purpose that day, yeah.
And you said kind of the same stuff, but let's be clear. You had mace that day, is that correct?
Yep.
Did you have one can of mace or more?
You know, I thought I had 2 cans. I may have had 2 cans. I may have had 2 cans. I only see 1 can here. There's a possibility that somebody else that showed up that didn't have one, let them use it, but I thought I started out with 2. There may be one on the other side. I don't know.
So is it fair to say that in that group, you guys will pass around the bear mace as people need it? Is that fair?
If somebody shows up that doesn't have any protection, then yeah, I would probably pass it off to somebody.
And similarly, they would give it to you if you needed it, correct?
I would hope so.
I didn't hear in your direct testimony about whether it was a smoke bomb or tear gas canister that you had as well.
Gas.
It was a gas, like tear gas canister.
Yes.
Okay. And in fact, during the melee, which we'll get to in a minute, you actually, I guess you pull a pin, is that right? How does it work?
You press a thumb tab on it and it stays pressed down.
Oh, and then you throw it,
Yep.
right? Okay. And you deployed that, is that correct?
Sure did.
Okay. So if I understand correctly, then so far we've got the knife, we've got the gun, we've got the paintball gun, we've got the flagpole, mace, you've got a tear gas, is it a canister?
Mm-hmm.
Okay, canister. You have your riot helmet, you have your riot padding. Are you wearing the knee pads that day as well?
I am.
Okay. And you got your boots on, dressed for battle?
I'm dressed for free speech in Portland.
Now, Mr. Swinney, are you saying you only wear that material in Portland?
I wear that material in places that are infested with black bloc Antifa.
So in other places as well?
Yeah, not just Portland.
That particular firearm, where'd you get it?
Objection, relevance.
Sustained.
That particular firearm, were you familiar with it?
Mm-hmm.
Had you shot it before?
Yep.
You knew how the basic operation?
Yes.
You heard Officer Ashheim's testimony. Did he give a pretty accurate description of the inner workings of the firearm and how it operates?
Yes.
It is, in fact, a Ruger Blackhawk 357.
That's correct.
And we didn't go great in depth about calibers, but you're familiar with firearms, is that correct, sir?
I was in the military, yes.
And you understand that there's a vast difference between, like, say, a 22 caliber and a 357.
Right.
In fact, oftentimes a 357 can be used to, and that one's a 357 Magnum, right?
Right.
It can be used to kill things like bears. Is that correct?
I would, if I ran across a bear, I would hope I had something bigger than that.
Well, maybe we all would. But you can, in fact, kill a bear with a 357. Is that correct?
I'm sure. Yeah, I'm sure.
Okay. And it is a very large caliber handgun, correct?
You know, it's. I think that the most common caliber is the like a 38 would probably be something that more people used. So 357s. There's things that make it higher velocity, and velocity is what does the damage.
You can also carry a larger grain bullet with it on that. Is that correct?
I'm not super familiar with the different grain bullets.
Okay. And you talked about the Magnum quality makes it so it has higher velocity, right?
Right. The barrel makes it to where it has a higher velocity on the length of the barrel on that weapon.
Is it fair to say those bullets will go right through people as well?
It's safer to say that that's a more accurate firearm. Did you say what?
The bullets that come out of it will go right through people. Is that fair to say?
It would, yeah, it's a gun. I mean, it's,
And you agree, to load that firearm, you have to open that window on the side, drop those, and the 357 Magnum cartridge itself is actually a little bit longer than a lot of pistol cartridges. Is that fair to say?
it's I mean, the same, like you can use 38 ammunition in a 357,
Agreed. Did you have 38 ammunition in there, or do you have 357?
357.
Okay, so then let's talk about 357. They're a little bit longer, correct?
They're about like a 38 round.
And you got to drop them in each one,
Right.
right? And then you have to actually, maybe do it with one hand, but you have to move that cylinder each time you drop a new one in, correct?
Correct.
Okay. And when you loaded it, and your testimony is you loaded it that day at the rally.
I loaded it at the rally, yep.
How much ammunition did you bring with you?
I think just the 6 rounds I had in my pocket.
That wasn't the only time that day that you talked about needing to shoot someone. Is that correct?
No, it's the only time I talked. It's only.
There was never a time where you tried to instruct other people that maybe they should shoot someone?
Oh, I told, so, yeah, and there's even in one video where I said it, I told everybody to get their guns ready because they're talking about shooting people.
Get your guns ready. In fact, you told people to bring guns to this event, didn't you?
I told people if they were bringing guns to this event, that they needed to make sure that they were unloaded. I didn't tell anybody to bring guns. I told them open carry is legal in Portland, and if you're gonna open carry, the weapon has to be unloaded.
But that wasn't all you said, isn't that correct, Mr. Swinney? I mean, you said, you knew, you went on to talk about how, what good is an unloaded gun?
I said, I know you're gonna, because whenever I say that to people, a lot of times they say, well, what good's a weapon if it's not loaded? And I mean, I agree with that. A loaded weapon's a paperweight. I mean, an unloaded weapon's a paperweight. But we have to play by the rules. We have to.
But that's not all you said. You said that something about an AR, right?
I told them that downtown Portland's dangerous. I mean, I'm like where I'm from, there's not criminals running around destroying the town like there is in your city.
I understand that's your perception, but that wasn't the question.
So your perception is look at downtown. Look at downtown, the condition it's in.
Again, I understand that's your perception, but that's not the question. I'm going to ask you to answer the question for me.
Mhm.
So the question is, did you also talk about people bringing ARs and being able to load them very quickly?
Right, because if they say what good's a weapon, then that's not loaded. It doesn't take any time to load a weapon, load an AR.
And so to be clear, when we're talking about an AR, we're talking about a rifle that shoots a .223 caliber, or potentially the military equivalent, correct?
Mm-hmm.
And they can bring, those ARs are able to seat high capacity magazines, is that correct?
Your laws for your city says that they're allowed to do that.
That's not the question, sir. The question is, does an AR allow for a high capacity magazine to be seated in it?
Yeah, 30 rounds. I think they even make a 42 round.
So you were suggesting that people should bring those rifles, or if they were bringing them, that they should bring them and have them ready to be loaded. Is that correct?
It's a dangerous place.
Yeah. When you got there, there was a motorcycles coming in, correct?
Correct.
And then you stood with your group for a bit. Did you talk to some people?
What do you mean? Did I are you talking about, did I have conversation with people on my side or?
Both sides.
I spotted a couple of guys on my side that I knew, and then I just started, there was a lot of attention that needed to be addressed to what was going on the line right there, so I broke off that.
The line. Okay. And at some point, did you pull out your mace and start threatening to mace various people? Is that correct?
People that were talking about attacking other people, yeah.
So you had your mace out. You were showing it to people. In fact, I think you were telling people at one point that they were going to obey the law. Is that correct?
Yes.
And essentially, you were saying you were going to be the one to enforce that law. Is that correct?
You know, if a cop's not around,
Oh.
laws they're going to be obeyed.
They're going to be obeyed. Okay.
Yeah.
And so, are you in law enforcement? Are you sheriff with Multnomah County? Are you a Portland police officer, federal officer, anything like that?
If somebody's breaking the law, I don't have to be a police officer to take.
That was not the question, sir. The question is, are you a police officer?
I'm not a police officer.
Okay, so you're not a law enforcement officer.
No.
And so your permit that you had, it gave you specific authority and allowed to control traffic and tell people where to go. Is that correct?
I wasn't doing anything with traffic.
Okay, but the permit you had said you could tell people where to go and you could control traffic. Is that correct?
No, their behavior was,
Well, isn't it true you didn't have a permit? Is that correct?
don't need a permit.
In your mind, you don't need a permit. Is that correct?
You don't need a permit to demonstrate.
But you had no authority to tell people where to go. Is that correct?
No.
Okay. You heard the audio calls and the audio clip. Is that correct?
Of what?
Well, they were of you, but we can play them.
The audio calls or
Yeah.
are you talking?
The phone calls.
Oh, yes.
You heard those.
Yes.
And you agree that that's you on there?
Mhm.
Right? I think there's 90, 91. I think there's a couple others. I'll make sure I get them all correct. But
It's 3, I think.
yeah, sounds right. So 90 and 91, and then there's another audio clip at 100. That's the one that's it's you talking to another woman. It sounds like maybe you're driving around. It's not a phone call though. You agree?
I know which one you're talking about.
Yeah. You agree that's you though, correct?
Yes.
Okay. And then in that writing, that's your writing, correct? You wrote that about how you're from Texas. You came to Portland to deal with Antifa. Is that correct?
Mm-hmm.
So that's your writing as well.
I think there's only one thing you entered into evidence that was writing, right? So that has to be the one I'm thinking of.
Handwritten, correct. I think
Handwritten.
you remember that.
Yeah.
It's fair to say in those phone calls, like you don't feel bad at all about what happened. Is that correct?
About what happened to, you have to let me know which one you're
Sure.
talking about.
You don't feel bad about what happened to Mr. Britton. You don't feel bad about what happened to Ms. Stewart, right? You don't feel bad at all about what happened to her. Is that correct?
I don't really have any feelings about it.
Okay. And in fact, in those calls, you talk about giving out life lessons. Is that right?
Right.
Did you give the young person on 4th Avenue on August 15th a life lesson when you sprayed that person in the face with a mace?
Hanging out in angry mobs, so it's not a good thing.
So you gave her life lessons, correct?
It wasn't a female. It was
Okay,
a man.
you gave the person there a life lesson. Is that correct?
I don't know that, I don't guess I was telling that person to stay away from my group. So, you're attaching that one time when I said handing out life lessons to everything that you've seen me do on there. So
It was the same day, correct? It was someone, there was an agitator, as you said Mr. Britton was, correct?
yeah, it was. I was really the life lesson thing was I guess it was more towards uh, uh, Britain there, but I see what you're doing, handing out life lessons. That was trying to keep somebody out of our group.
Okay. In that video, you talk about basically and I apologize, in the audio clip where you're talking to the woman, it's not the jail calls. In that audio clip, you're talking to her about how you need to get video of these like little assaults and these little, you talk about someone touches or hits the flag, that's an assault, right? You got to get 2 or 3 or 4 of them, and then it's go time. Is that correct?
I'm telling her that you have to that we have to capture videos on assaults before. Really, what I'm telling them is don't put your hands on anybody. Don't put your hands on anybody. We can never be seen as the aggressor. If somebody on our side puts their hands on somebody first, then we're the angry mob, right? So we avoid that at all costs, and we don't touch anybody until we catch this stuff on video, and only then if the cops aren't around. If the cops aren't around, if these assaults keep happening, they're caught on video, then it's go time. Yeah, it's go
Isn't it
time.
true you went to Portland looking for a fight?
No, it's not true.
I'm gonna bring up
Judge, I have a brief matter for the court.
Okay, come on back. All right, Mr. Vasquez, you can continue.
Thank you. So where we just were, I asked you, you came to Portland looking for a fight. Is that correct?
No, I came to Portland to help friends out that were.
Well, then let's go ahead and take a look at, we'll start with State's Exhibit 1. Do you see State's Exhibit 1 in front of you? Do you agree that that is a printout of your Parler post from July the 7th of 2020?
Yes.
Okay. And you are the user at Al was here? Is that?
Yes, this is me.
Okay. Can you please read from where it says, please help by sharing?
Objection. The evidence speaks for itself. If he wants to ask questions about it, then go right ahead.
People read posts the entire time, including the witness.
I mean, he did read his other Parler, so overruled. You may read.
Please help by sharing this post. We need patriots to follow us. We need to be able to get the word out about these events. We're boots on the ground, the absolute tip of the spear as far as the right's answer to the left's violence. Help us by following us. Help us get the message out. Please echo.
See State's Exhibit 2?
Uh, the Last Crusade has already started. Join us, follow me.
And that was posted on the same day, is that correct?
Mm-hmm.
And then States Exhibit 3. This was posted on July the 15th of 2020, about, what, about just right at a month prior to it. What does this post say?
If you're down to do some real patriot shit, follow me. If you don't know who I am, search Alan Swinney in Google. We're literally fighting the militant wing of the left. We need your help. We can beat them if we work together.
We see States Exhibit 4.
If you're in the Portland area, come on out. Flag waves are tons of fun, and they're just enough libtards around to make it even more entertaining. If you have people from Oregon following, please echo this post. If all this stuff has been pissing you off, here's your chance to do something. Even if you can't be here yourself, echoing this post will boost our numbers. This group is actively fighting the left, not figuratively. We get toe to toe with these people. Come help us. We can do more if we work together.
States Exhibit 5 as well. Yes.
Yeah, I want to make sure it's the right version.
Yep. And you would agree that that's what you wrote, right?
Mm-hmm.
You wrote that. Is this a post that you also wrote?
It is.
And in this post, you specifically say it is a civil war, correct?
It is. I believe it is. It's two different ideologies, and one side's bringing violence to the table to further their political objectives. So.
You see States Exhibit 11. You had stated on your testimony with Mr. Westover that you were hoping for, and I don't know if I have the quote here. Said you want to just go have a peaceful flag rally, and that I apologize. 1 moment. Two yellow pieces of paper. It was something to the effect of that you'd be delighted if no one showed up.
Mm-hmm.
Can you read States Exhibit 11?
Portland, Oregon, Saturday, August 22nd, 2020, Justice Center. This is where we hold them. This is where we fight.
Oh, I'm sorry. Here it is. You said that you'd be tickled to death if no one showed up to oppose your group. Does that sound accurate?
Yes.
Nothing further, Your Honor.
All right, any redirect?
Just a little bit.
Mr. Westover, apologize.
last over. Could you bring?
Yo, you want some more?
Uh-huh.
Okay, so just a few, I want to talk about the phrasing of one of the questions that Mr. Vasquez asked you. When he was talking to you about having attended rallies at various parts of the country, he used, the question he asked was, at all of them, are you confronting Antifa? Are you going, how often have you gone, are you going to Antifa rallies and interrupting their rallies?
I've never been to anything that any of their, I don't go to their things. I don't go to their things.
Okay. So when we're talking about the events that you attended in the past where, as Mr. Vasquez put it, you're confronting Antifa, those are, just describe the nature of those. Are they similar to these flag waves that we're talking about in the 15th and 22nd?
The reason I started doing this was to help. I would watch videos of things going on around the country, and at the time, like around 2016, when these things were going on, Antifa would show up and attack these rallies. At this time, it was, I know I'm old too, but it's just older people that go to these things, right? And these young kids were coming and attacking these rallies. So in my mind, then it was, they need help with security. So
Okay.
that's why I'm going. I'm going to places where I know already there's going to be a confrontation. I know that. And uh, and I'm tired of them preying on this other peaceful side. That's nothing's going on. So that's why I go to these things, and I'm going to help them with security. And I'm not flying from Texas to Philadelphia, Pennsylvania for no reason at all. I'm going there to help them with security. I'm going to help them.
Okay. And the events you're going to help with security, are they circumstances where, you know, it's a Black Lives Matter event that you're going to?
No, it's going to like a We the People rally or a free speech rally or something like
Okay.
that.
Conservative
Or Back to
rallies,
Blue
those are what
rally
you're going to.
right.
So in the times that you've had to, you know, in the times that there have been physical interactions with folks, those are circumstances where you're at a rally and they have come to your rally
Yes.
to interrupt
Yeah, every time, yes.
every time. Okay.
Well, I mean, like every rally I've been to, they haven't necessarily came there, but every time it's them coming to a rally I'm at. It's
Okay.
not me going to.
That's a good question. Is it has every rally that you've ever been to been interrupted?
I went to one in Washington D.C. where there was no sign of Antifa, and that's probably the only one.
Okay.
I go to places where there's a chance that somebody's going to show up and attack the rally because I'm just going to help security.
Okay.
Right? So if there's no security necessary, there really wouldn't be, I mean, a reason for me to be there, right? But I go to places, and now the places that I've been to have friends at them that I have, and when they have rallies and they need help with security, they'll let me know.
Okay. Let's see. Mr. Vasquez asked you a number of questions about particularly the person who you shot in the mask. With one hand, they were holding a phone that may have been recording or a camera, say something like that.
Mm-hmm.
Now, on those videos, I saw lots of people holding cameras.
Mhm.
Is that a common thing when these types of events are happening? Lots of people holding cameras?
Yes.
Are you aware of any strategies that people that come to interrupt your groups use using people holding cameras?
Oh, yes.
Can you describe what those are?
They'll use, and even on that 22nd rally especially, they would.
You're gonna object?
Overruled all out.
They'll stand there'll be several of them standing shoulder to shoulder, all holding cameras. And I'm sure it would be speculation to say what they were doing, but what
Again,
they.
I'm gonna renew my objection, Your Honor.
Do, oh,
So I think,
what they do is what I'm gonna say.
Your Honor, speculation is the state's objection.
Right.
overruled, he can testify what he's seen them do.
Because they're standing there in such a close proximity to us, the other side uses them to get behind and throw projectiles at us, or use them to launch attacks from behind them.
Okay, so there are experiences you've had where somebody holding a camera, turns out there's somebody sneaking up or hiding behind them.
Using them.
Right, and what does that enable the person sneaking up to do?
To get closer to you.
Okay, and when somebody is closer to you, is it easier for them to hit you with something?
Yeah, and it's a ha-ha thing too for when they're throwing projectiles, because like, oh, I'm behind a press guy. You can't throw stuff at me, or you can't retaliate against what I'm doing to you.
Okay. So I guess we didn't get to that on direct, but a person, does it create a concern for your safety and the safety of the members of your group if somebody with a camera, just a camera, is getting too close to you?
Yes.
And so Mr. Vasquez also was asking you questions about all of the things that you had done on August 15th prior to when Jason Britton was hit in the face. And he said, well, you had maced the crowd at one point, and you had put bear mace in the face of the person that was getting close to you, and you had shot somebody in the stomach with your paintball, and you had shot somebody in the mask with the paintball, and you had shot other people who were approaching you with weapons.
Mm-hmm.
Even having done all of that, did that stop the crowd from following you?
No, they followed us. They were there until even after we got in the parking garage, and then they were chasing through the parking garage
So
as we
let's-
were coming down. Okay.
Yeah. What do you understand goggles to be versus a mask?
They just cover the eyes
Okay.
instead of the whole face.
So goggles just cover the eyes,
Right.
and then what does a mask do in the way you use the word?
Some masks cover the whole face. Some just cover the nose and mouth.
Okay.
They wear those there to keep the bear mace off of them, so the bear mace doesn't affect them, or the mace doesn't affect them.
They're the masks that will. It sounded to me like you said that mask could cover both eyes and respiratory, or just respiratory.
Right.
But it would be goggles would be just covering eyes.
Right.
Okay. Let's go. Can we pull up States 52?
I don't have to.
We can help with that.
Thank you.
Photograph or videos?
Oh, I don't have my list. Let me see. I'll grab my list.
52 video.
Hmm?
Is it a video or?
It's a video. It's the longer Jason Britton video.
Got it.
Can we go to the portion of the video that sort of leading up to Jason Britton being hit? Let's go right here. So, Mr. Swinney, I'm going to ask for this video to be played through the end of it, or until I say stop. But can you just describe when you see yourself looking back over your shoulder and trying to keep an eye on what's going on behind you? Okay.
I'm sorry, did you ask me to play it?
Yes, would you
Sorry,
please? I apologize.
I wasn't paying attention.
Pay me all you want. I'm still gonna follow you around this town till you leave. Go back to Texas, buddy.
Looking back.
Oh, that's fine. What are you gonna do? Beat me?
Pause.
Oh, okay. I know what you're talking about.
Yeah, yeah.
I thought you were saying every instance.
Oh,
Okay.
yeah, if you can do every instance of when you see looking back,
Okay.
and maybe just like we did with the Tinks before, just do one of
Okay.
those when you
Okay.
see yourself looking back.
All right.
You go back to where we were before,
Sure.
10 seconds. So,
About right?
sure.
Go back to Texas, buddy. Oh, that's fine. What are you gonna do? Beat me? You gonna shoot me with your paintball gun? Fine, do it. I am not threatening you at all. So if you want to beat me and you want to assault me, I'll see you in court, buddy.
I'll see you in court, buddy.
All right. Just shoot that right by my head. Oh, you just shot
Thank
me
you,
in the
Mr. Clark.
eyeball.
We're good. So that was, at least once every 5 seconds or less.
Hmm.
Okay. The American flag that you have on your pole, you actually acknowledged that it was maybe even a little smaller than an 8.5 by 11. You said you testified you were in the military.
Yes.
Was there an American flag on your uniform?
There was on in Iraq.
Okay, and was that American flag patch on your uniform smaller than a regular piece of paper?
Yes.
Okay. Talking about the gun, the Ruger Blackhawk 357. That's what you had on August 22nd.
Yes.
Did you tell Detective Jones what kind of gun you had that day?
I think I did, and I posted it was in posts, and I made no attempt to hide that. I'm almost positive I did.
Okay. Did you bring an AR to the 15th or the 22nd?
I didn't.
And then I guess the movie 300, the clip on the you said this is where we stand, this is where we hold
This
it.
is where we.
Yeah,
This is where we fight.
Right, the plot of the movie 300? What is the plot of that movie?
They're defending an area.
They're defending an area
from aggressors.
Okay.
And they all have spears.
Nothing further.
All right. Mr. Swinney, you may gather your things and return back to council table. No witnesses, Mr. Westover.
Give me one moment.
Okay.
Yeah. time defense rests.
Is there any rebuttal case that the state would like to?
No, Your Honor.
All right, I'm gonna ask the attorneys to pop out into the hallway with me so we can talk for a few minutes about timing and see where we are.
Defense rests. So from my understanding about the process for the trial yet, I really don't expect this is going to end today. There were still some unresolved questions about jury instructions, as well as the judge needs to read explanations into the law for the different charges, and they need to make closing statements.
So as you know, we hoped that this would be getting to you by today. It is not getting to you by today. We need you to come back in on Monday. I think what makes the most sense is to send you home now at 3:00 on a Friday instead of try to jam a few things in this afternoon after you've given us your great attention these many days. So you can return on Monday bright-eyed and bushy-tailed and ready to hear my instructions and the closing arguments in this case. Then we'll get the case to you to deliberate. So I apologize that it has going to take us. This trial is going to take us into next week. I assure you, we have worked many of the times that you all have not been here. We have been working to try to be as efficient with your time as possible. Unfortunately, it just took longer than any of us had hoped. So, Mr. Keenan will get you back into the jury room. By show of hands, if you had a choice between bagels, pastries, or donuts on Monday morning? Bagels. All right. Bagels it shall be. See you Monday morning at 9:00.
Can we get bagels? I would like some bagels.
The judge puts a reminder in his phone.
Actually, there's a place I know in Vancouver that delivers to where I live called Seize the Bagel that does amazing stuff.
Monday morning, pick up bagels.
And yes, he did bring his gun downtown unloaded and then loaded it on the scene because that
Are we on?
is the way that state or
Do you need a minute to
city
talk to
law
him about?
is structured.
Yeah, I think just a brief minute.
Oh.
Would you like us to step out while you talk about?
Please.
Thank you. I know we are.
So, yeah, I think the focus at this point is going to be going over jury instructions. Since there's no more testimony, I don't think there's any way to do anything else with new evidence. Oh, I will just, oh, that is not who I... Okay, the question about impeaching a different witness. Yesterday, the defense was trying to impeach the testimony of Meg Stewart because of some slight differences between her grand jury testimony and her trial testimony. Um, as far as the comment about the Rhinell family, I presume you're talking about Mike Rhinell's case. I'm not sure that anything dealing with Alan's case is going to be relevant. And I will say that as somebody who has been following that pretty closely. Mike's brother and I have been incredibly close for long before I moved to Portland, probably close to 12, 13 years now. So that this has been, the whole incident with Jay Danielson and Mike. There's a lot of strong feelings about it. I know that much. And yeah, Meg, the difference is that defense second chair was trying to bring up to attack the credibility. They were very minor, and it was more. It felt to me more like interpretation of the question and the answer than that. As far as what you might have missed in the last few minutes, Mr. Swinney finished his testimony and cross-examination. They ended the trial for the day. Said that they will need to hold this over until Monday, and after that, they basically just took a break for a few minutes, and I think they're going to come back and go over questions on the jury instructions that'll be given out tomorrow or Monday. Now, as far as Monday, what's going to end up happening is the judge has to read out explanations of the law regarding the different charges. There'll be the jury instructions that get read out. Then the state and the defense make their closing arguments. Then they go to deliberations. I suspect half to the whole morning will probably be taken up with trial stuff, and then deliberation starting either late morning or early afternoon. As far as for multi-stream, I do have it on Twitch as well as Facebook. If you look down in the YouTube description, there's a Linktree link, and it has all of the channels and social media and everything in there. We do not have audio from the courtroom yet, so whatever is being said, I do not know. Yeah, I'm just going to say, I'm not documenting specifically if people are making threats against witnesses or against other people, but comments are showing up in the chat on the video, and they are archived to YouTube through the live stream, as well as downloaded to my server. So, I may catch stuff and remove messages from chat, but just don't do it. I don't know what kind of crime there might be if there's, witness tampering, harassment, things like that, but really just please don't do it. I mean, there are people here who are talking about both sides need to focus on what we have in common instead of focusing on our differences and trying to attack each other. Uh, I can't undelete, but I can view. Um, I'm gonna discuss this with Jason privately because I know that's where the question is on that. Yeah, the karma bus was kind of interesting. Okay, we are not on the record yet. I think they're leaving the audio off. I mean, and maybe you're right that I have too much naivety and too much goodwill towards other people, but I grew up in a deeply conservative evangelical home, and yeah, when I grew up and moved away, I ended up doing a complete 180 from what I had growing up, and there is a part of me that can see things from both sides and be able to an extent understand where some people could be coming from. I'm not saying that I totally understand where some of these people are coming from, but um but as somebody who has been dancing on that one side of the extreme and have come out of that, it's just yeah, I have to believe that there are still people that can come back. Um, as far as talking about Mike's whatever's going on with his wrongful death case, I if he had been taken into custody, I think this kind of stuff could be hugely relevant to a self-defense claim for Mike. Now, keep in mind, after his death, the DA dropped the charges against him, because you can't prosecute a dead man. So technically, he's innocent of that charge. Um, but I'm not sure that a defense for the underlying crime would necessarily play into this. This testimony this long after the fact. If he had testified like the day before the grand jury indicted Mike, then I think that would be a different question. But this is 13 months after. Oh yeah, and as far as the question with Jay, and I really have a lot of questions about the shooting. Mike said that he thought Jay had a knife. Well, there was a collapsing baton found on the scene. I could see very easily somebody confusing a collapsing baton for a knife, because in the dark, in the heat of the moment, the two could look similar. Um, and there's still a lot of questions that I have unanswered that I'm not sure ever will be answered. I've just had to accept that. Yeah, video that I've seen, they try to claim that there was nobody around Mike. I've had trouble in my head parsing the video to figure out where everyone was, but And for what it's worth,
and I will even characterize it as passing reference to a jail call. Within moments, Mr. Westover had a matter for the court. We stepped outside. Mr. Westover, because his client was on the stand, wanted time to consult with the client after his testimony was completed, as opposed to interrupting the proceedings entirely. They have consulted, and my understanding, Mr. Westover, is that the defense is neither moving for a mistrial, nor are you asking this court to give any kind of curative instruction.
That's correct, Judge.
All right. Thank you very much. And so now we can begin discussing jury instructions. As I noted in the email that I sent to you all, it is entirely possible that I missed something that someone asked for when I was trying to consolidate everything into this form, but I did my best. So let's start with functions of the court and jury. I did add the political affiliation phrase and left in the line because it's a uniform instruction that Mr. Westover had highlighted. Evaluating witness testimony is the second instruction that I'm going to give. I did remove 5 and 6. Now, with regards to witness false in part, I don't even remember if we did it on or off the record at this point. I think it was off the record. There was some back and forth about now perhaps the state also wanted it and then maybe the defense didn't want it. So where have we all landed?
State will request it.
Let's do it.
All right, it'll stay in. I'm going to stay in it. I'm going to keep it in like that without calling it out as a separate instruction. Defendant statements, I believe that is completely as proposed by the uniform instructions. Non-expert opinion evidence, modified evidence, inferences, direct and circumstantial evidence. Self-defense. I used the uniform jury instruction as opposed to the defense's requested one. I said in my email to the parties that I would put on the record my thinking on that. I read Oliphant again, I feel that the whole suggested language by the by the defense about the lawfulness of self-defense, that really is related in Oliphant to the fact that the force was used to resist arrest, and a person, is more legally limited when using force with resist arrest, or at least there's an argument to be made there. I'm not trying to set any precedent of any sort. And I felt that the defense special or modified 1107, by talking about the lawfulness of the force, has great potential to confuse the issues. I don't think the jury needs to be deciding whether, I just think that I did not like it because I felt like the phrases about lawfulness would confuse the jury.
If I could be heard on that, Your Honor.
Of course you can.
I believe your email said it was dicta.
Well, okay. My email's not part of the record unless you want it to be. B, I did say dicta in the email. I don't know that I really meant dicta in its formal sense. But go ahead, nonetheless.
I would like to recite a case that I did cite in my requested, which is State v. Carlin.
And remind me of that site.
265 or app 390.
Okay, let me pull it up.
One more time. The site, please.
It is 265 or app 390. And 396, 397 say this is an assault case. It's not a resist arrest case, and the state relies on Oliphant to indicate that the court erred in its instruction, and it uses the same language. It quotes Oliphant, it, including that according to the court, the self-defense statute, quote, makes the defendant's reasonable belief that unlawful use of force was being used or was being about to be used against him paramount. It specifically quotes Oliphant in a case that is not a resist arrest case.
Right after read it. Sorry, I only read Oliphant.
There will inherently be some typos. Well, that's what we do.
Yeah, but yeah, if you note them because I'll fix them. So I
am willing, and this state can be heard on this, I'm willing to add a defendant who raises the defense. So if you're looking at what we have now after this second paragraph, so in defending a person may only use that degree of force which he reasonably believes to be necessary, period. New paragraph. A defendant who raises the defense of self-defense has the right to have the jury consider the circumstances surrounding the event from the defendant's point of view. The paramount issue in considering self-defense and defense of another person is what the defendant reasonably believed at the time he used physical force. But not the stuff about the lawfulness. I think that gets confusing.
Okay. I'll concede that.
Okay. Does the state want to be heard on that at all?
No, you're.
Okay. Let me put it in right now.
Did you look at the? Did you look at the other two paragraphs?
Yeah, we need to talk more about this.
Yeah, no, we're not done talking about the rest of the self-defense. This is just this one part.
Looks like it's what, 3.
All right. So you no doubt saw that I then went on to talk about the mutual combat and aggression in the same thing instead of calling them out separately. Those were things I did not include provocation. So
So provocation's out.
I took it out.
Okay,
I'm
that's fine. We don't want it.
willing to
Yeah.
hear more argument, but I thought that the case law was probably disfavoring us to this, but I'm happy to hear why I'm wrong.
Yeah.
We may just have a moment here.
Of course.
Here, we'll just we'll withdraw that request.
Okay, provocation is out. Aggression. Aggressor. Initial aggressor / aggression. Say
I'm,
that fast 5 times on Friday.
I'm curious what evidence there is that Mr. Swinney is the initial aggressor. What's the basis for the request of the instruction? These are all state's requested instructions.
Yep.
Your Honor, there's evidence both in the videos and in the record of him spraying mace towards people, that he takes actions. He is pointing paintball guns at times. There's various points throughout the life of the case, both on the 15th and the 22nd, where he is taking actions that are beyond his words, but are his actions that work towards that instruction.
Mr. Westover.
We forwarded a case to Your Honor. I've had a chance to, I think Ms. Desai may even have a printed copy of it.
I mean, I feel like I read them all in the morning, but it has been a long time.
So, State v. Phillips certainly says that words are insufficient to constitute the initial aggressor.
Oh, yeah. I maybe was getting this one confused with the provocation one, actually.
I still don't get it. Why? I mean, this says, you know, their words alone are insufficient.
Yeah. Yes, it does.
Right. But I honestly don't understand how the evidence suggests that. They're suggesting that Alan Swinney is the initial aggressor. I mean, if you remember, we fought over this jury instruction last time because the police thought the state's position was rolling a window up as an act of aggression. My position was, if you give it, the jury's going to laugh at the state when they argue that. I think that it's probably similar here. The evidence is we cannot use any of the parlor posts, anything like that, to suggest that Alan Swinney was the initial aggressor. First of all, with regard to those, there's actually contrary evidence that anybody that was there knew about any of those. Jason Britton had never heard of Alan Swinney before. Meg McLean didn't even know what the Proud Boys were. And then we've got several unidentified complaining witnesses that there's no, you can't assume they knew anything about it. So there's a significant risk, first of all, that having these parlor posts and then giving the initial aggressor is going to cause a substantial confusion among the jury. But the fact of the matter is, the entire time Alan Swinney is walking away. And then in terms of the charged conduct that we have here, at least and this is, again, they've muddied the water with this whole, he's committing the crime of unlawful use of a weapon the whole time. If he's committing the crime of unlawful use of a weapon the whole time, then there's no such thing as initial aggression. Then you might as well direct a verdict on those, because he could have never abandoned. When it comes to the complaining witnesses that we actually know about, the Meg Stewart is hoopty-doopty walking along in a park minding her own business, then all of a sudden Alan shoots her. That's the theory of that. There's no basis for initial aggressor there. There's no indication that she had ever even conceived of the notion of Alan Swinney prior to they just got hit in the tit with a paintball. In addition, with regard to Jason Britton, he's walking away the whole time.
Would you like me to respond, Your Honor?
Mm-hmm.
So, first of all, with Mr. Britton, we'll start on the 15th. There's information where he's walking along and we see Mr. Swinney spraying mace at the crowd in general. He sprays high over the head and is spraying it towards them. This is a act of violence. It is a very direct piece of evidence, act of violence. Not to mention that the court could also look at, he is carrying around these things. And at times he has his mace out in his hand. So he is doing things that cause him to be the aggressor. He's the one, and then when they get to 4th Avenue, he turns and he shoots a guy in the stomach. And that is an example, of a first aggressive act. And that is why you see those other people walk up to get film of him or do this or that. And then he then shoots or maces them. So those are some actions where he's taking. So
Okay. I think that what Phillips says is, I have to find it again. I should give the instruction when viewing the record, it would be rational for a fact finder to find in support of the party's theory who is requesting the instruction. Here, there is a theory where Mr. Swinney could be considered by the jurors to be an initial aggressor in some of the actions that he took on both dates, and so I will give aggression.
So, I mean, if he's committing a crime the entire time, then it is impossible to abandon that, right? As I said, you might as well direct a verdict.
I disagree.
If they argue it's impossible to abandon, and therefore he must be guilty, that's improper argument.
I don't anticipate we'll be making that argument.
I would agree that that does put the defendant in an indefensible spot, and I would.
The way that defense counsel is phrasing, that's not something that I guess even crosses the state's mind of like how we're going to argue the case. So their defense is raising something that I think is a non-issue from the state's perspective.
We're asking then for a limiting instruction that the parlor post cannot be considered as initial aggression.
Agreed.
That absolutely is in the case law.
So it is the actions combined with the parlor post. It's the actions and the words that combine. That's the way that we can look at that as a whole.
Only one of you is arguing. Go ahead.
Right. So sorry, I actually want to go back to
Provocation.
No, I don't.
Okay.
I want to go to the uniform really quickly. I feel like this.
I'm remembering something else, and I want to check the uniform
Okay.
to make sure that I'm. Okay, so I'm remembering something else.
Okay.
I'm trying to get my brain back to where I was before I got distracted with this idea.
What Phillips says is that words on their own cannot be considered initial aggression. And what these parlor posts are words on their own. They were made at a separate time. They were made to a separate audience. They are, if you get initial aggressor, if those can be constituted initial aggressor, then anything the person ever said could be could be factors in determining whether the person was the initial aggressor. What we're talking about are the circumstance. It has to be limited to the time in which the allegations exist.
At the end of the paragraph, ordinarily a person is not just blah, 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 but the other person nevertheless continued or threatened to continue the use of unlawful physical force on the defendant, period. It is important. I'm spitballing here, so let me type it, not try to write it.
You're right. I guess the state's position would be that, and I'm sorry to interrupt I know you're in a train of thought, so I'll wait if you'd like.
Only because I think I have this document open twice and I need to close it once so that I am only working on one version. Hold on. Okay, I'm ready to listen to you.
Thank you. So, Mr. Westover would be correct, perhaps, if it were just parlor posts. Then, yes, savvy pain applies. Okay, not just words. If he rolled into town and literally was just wearing t-shirt, flip flops, carrying a camera, we'd be in a different situation. But we're not. His words inform his then actions. It helps the jury understand, well, why is this guy dressed for battle, coming in spraying mace? Well, it's because he told everyone, I'm coming to fight. I mean, those things come together, and it provides the context for his actions. Without them, it's like it creates a illogical divide between them.
Well, but I do see the defense's point to the extent. I mean, I guess there's a question about what we instruct the jury versus what I let you argue that how they should interpret the evidence. I mean, I feel like we're getting a little bit far afield here because I do think, as Phillips states, provocation by mere words, if unaccompanied by any overt act of hostility, will not cause a person to become an initial aggressor. So the parlor posts, this is why I'm struggling. The defense is right. I think at least the people who testified in court said they had not heard of Alan Swinney before these incidents, right? I mean, maybe Mr. Britton's buddies had reached out to him to say, like, hey, this dude is here, come check him out. But certainly no one testified, like, I knew when I got here that this Alan Swinney, I mean, I guess on the 22nd, some of them basically said, like, everything that happened on the 15th, and we knew who Alan Swinney was, but nobody specifically referenced the parlor posts. We'll put it that way. And so in that regard, he's not an initial aggressor from those witnesses' perspectives, right? I mean, they think he's the initial aggressor because of the manner in which he's dressed, because of the weapons that he is possessing, because of what he's doing with the weapons that he is possessing, and whether the defense agrees that that perception is a reasonable perception or not is something I'm sure will be discussed at great length in closing. The issue is then how to
Do you want to add a sentence that says something like initial aggression shall be viewed from the defendant's actions and actions alone?
I think we need to get more specific than that. Exhibits 1 through whatever may not, I mean, and in addition to what Mr. Vasquez has suggested, and exhibits may not be used to consider. Because the problem as well, and I was sort of getting at this earlier, is if those exhibits have come in for impeachment or plan to go downtown, motive for, I still don't get it, and intent, but those are other acts of evidence. Now they're saying, now if you allow them to be used as the initial aggressor, now they're saying he's acting in conformity with those.
So if the court puts in the exhibit numbers, it's going to be a comment on the evidence. That right there is going to be an issue. So I think if something of like words, alone cannot.
Just a minute. Let me try and
Certainly.
type something up. Both of you, just a minute.
Where's this read file? Anybody know why sometimes when you have a Word document open, you try and make it big again and it just won't do it? You know what I'm talking about?
No.
What,
Minimizing back.
huh?
It keeps minimizing back.
Yeah, look, so I go there, I want to open that one.
Got too much memory.
You know more about computers than you let on, Mr. Swinney.
Building the website since the internet.
Oh, really?
So here's what I'm trying to say, and I'm not coming up with it right. So if I say a long, rambling sentence about it, maybe you guys can help me with it. Mere words, if unaccompanied by any overt act of hostility, will not cause a person to become an initial aggressor. So now we have to talk about others' points of view, right? Because we've talked about the defendant's point of view earlier in the instruction. So now we have to talk about others' points of view. And then something about or maybe we just say that sentence. Mere words, if unaccompanied by an overt act of hostility, will not cause a person to become an initial aggressor, period.
I mean, I think there's a lot to be told, at least of our understanding of initial aggressor, beyond just these words. There needs to be an overt act. And so the state also wants to say that the fact of, for Alan Swinney's case, the fact of putting body armor on is somehow going to be, that's not an overt act, that's just a passive act.
Well, I think that's argument.
How? Computer just shocked me. Okay. Go ahead. I mean, I think it needs to be specific because of the very limited nature of the admission of these parlor posts.
I mean, can we just take a step back and realize that part of the initial aggressor instruction actually helps your client if a jury finds that he truly was trying to leave the scene and these people continued to bother him. So
Yeah, I mean, I guess I told you my position on, a layperson's receipt of the state's argument. I really want, there to be a limitation that it's just, for whatever record we need to make, that nobody could look at those jury instructions and think that any reasonable juror could do anything but conclude that those parlor posts may not be considered when determining initial aggressor.
But it says words and words alone, Your Honor. I think that covers it.
Words from a month and a half beforehand. I mean, there not only, to the extent that we're looking to criminalize words, there's imminence, there's requirements.
So here's the problem, and here's what I'm bumping up against. Again, there's how I'm going to instruct the jury as to how the law applies to the case, and there's what the two sides of you, 3 of you, 4 of you, however many of you are going to argue to the jury about how they should interpret the facts and the law in this case. And I agree with you that the parlor posts alone do not make Mr. Swinney an initial aggressor, which is why I would add the line, mere words and words alone, if unaccompanied by an overt act of hostility, will not cause a person to become an initial aggressor.
So,
I'm even happy to put that earlier in the paragraph, right after the first sentence.
so I think in that case, we need to revisit the court's ruling on the admissibility of the parlor posts and say that they are relevant, even though the state never argued that until the very end, towards Alan Swinney being the initial aggressor. That's not what they argued. It makes them other acts evidence, number one. And if you're hung up on, well, I feel like it's a comment on the evidence to say that the jury may not consider, the state's already conceded that the jury may not consider the events of August 22nd with regard to determining guilt on August 15th. And nobody was worried about that being a comment on the evidence.
Well, that's because the law requires a limiting instruction. So again, I'm not revisiting anything. If this, here's what I believe the state is going to argue, and I don't want to put words in Mr. Vasquez's mouth or Mr. Schweitzer's mouth, but the parlor, when the defendant said, I only wanted these to be peaceful protests, I was only there as security, Mr. Vasquez and Mr. Schweitzer or Mr. Schweitzer will say, no, that's not all he wanted. And you can look at all kinds of things to decide if he's the initial aggressor. The other thing we could do, frankly, is just take initial aggressor out.
The state's asking for it.
I know, but now I'm just feeling like,
You're right.
if you still want it in, that's fine. I just feel like
I would only forward this to the court, but I understand that Mr. Westover has vociferous arguments about it, and I appreciate his advocacy, but that's not necessarily a reason why we should become tired of the discussion and take it out. Because
all right.
So that
I'm ready to keep going.
Okay. What is the actual statute again for all the self-defense stuff?
the actual statute, I have that here.
It's in 161.
161.215.
Yeah.
Right, that's what I've been arguing. Whenever you're ready, I just want
I'm ready.
to try and reset it. I mean, I'll concede that words, whatever words Alan Swinney said that day, or those days, those could be, because those are words that are connected with his conduct. But these parlor posts that are posted to a completely different forum are not.
Uh, right now, I'm just adding the sentence, mere words and words alone, if unaccompanied by any overt act of hostility, will not cause a person to become an initial aggressor. I understand you object to that. If you want to provide additional proposed language to me over the actual language to me over the weekend, I'll take a look at it.
Okay, I think that, I mean, just my initial response to what you've written is let's just go get Webster's and look up what the definition of a company is.
Can I use dictionary.com?
That's not what the Court of Appeals uses.
The definitions that I'm getting from a Google search are, number one, go somewhere with someone as a companion or escort, or to be present or occur at the same time.
And those parlor posts are mere words unaccompanied by any action.
About mere words and prior statements.
I mean, let's not hide the ball. Those just cannot be, though you may not consider these exhibits when determining initial aggressor if the state insists on continuing to ask for it.
I like your first suggestion, which was that the parties submit language over the weekend, and then we can finalize this last one. I'd like to move on.
Right. So now you're tired of it too. I just want to know it for the record. Okay.
Well, I thought he said before, getting tired of it doesn't mean we should move on. That's what I heard him say.
Do we want the mutual combat one in there?
No.
No.
Yes.
Why?
Well, on the 22nd, there sure was
Yeah.
good evidence that there was mutual combat. If you want to put the only to be considered for August 22nd, that's fine, but for August 22nd, that is certainly.
It's just, I mean, I looked at, there's very few cases on this, Judge, and it's like a contract to fight is what we're talking about here. It is not what, I mean, there's a person does have a right to resist an arrest made by an officer. The fact that the officer is voluntarily agreeing in whatever force they're doing, and the person who is accused to be resisting them is voluntarily engaging in that, does not mean it is mutual combat. And that's the same with this. Just because we cannot confuse the words voluntarily and mutually.
So I'm struggling with mutual combat still. I've just got it highlighted. I need to look a little bit more over the weekend, or I'm open to you guys sending me more about it.
Certainly are. Thank you.
All right, how to consider the evidence. The only thing that I think perhaps we need to discuss is whether, well, no, I don't think we do. Is the defense okay with the some evidence applies to both dates, and you may consider exhibits 5, 6, 7, 90, 91, 100, 101, and 102 for both.
I have not had an opportunity to read the entire instruction yet.
Okay.
Go ahead.
I mean, everything else is the way you wrote it, but.
Oh, okay.
I think.
Okay. Considering that I will die on the hill of the parlor posts cannot be used in initial aggressor, I would need an except as otherwise noted.
That seems. I'm going to put it in and highlight it depending on how we end up with the. I think we can play with that. I'm not saying for sure that that's the exactly perfect language, but in other words, Mr. Vasquez, if we're going to add mere words alone are not enough for initial aggressor, I've got it highlighted. I'll resend this to you guys with the highlights. That and highlight means we probably still need a few more minutes to discuss. Okay. Attempted assault in the 4th degree. Any issues with the way that that's drafted? Including, by the way, I think Mr. Swinney said he had seen some typos, so.
He caught all of my typos on the documents that I've given him, so. I think the only thing I would add, just to make it abundantly clear, is the election. Intentionally attempted to cause physical injury to another person by.
No, you are. There's no requirement to add that like to-wit language. So I don't think that's necessary. I think again, it's defense trying to relitigate another issue it's not for the jury instructions.
It is. We haven't even got to this issue yet.
Well, I mean, you did make the election for which person it was, so I guess the only question is, I mean, I can say Ellen Swinney intentionally attempted to cause physical injury to another person.
It's been clear who we're talking about. If they would like, we could put some notation on the verdict form.
Yeah, I actually think that's cleaner to put a notation on the verdict form.
Yeah, let's all read page 421 through 428 of Payne for our verdict form.
I mean, you have not submitted a verdict form, so I'm not going to read it right now.
The state does one, but maybe I'll write one this time.
Well, you're the one who said you wanted one with interrogatories, so.
I said that's what we'd be asking for. I didn't say I'd write it.
Well, I'm not writing it.
Okay.
I wrote a standard-ish one. I mean, there's a concurrence issue that needs to come up, or needs to get cleaned up, I think, on the other count. Yeah, so I think it makes more sense in the verdict form, and I'm happy to take a stab at the verdict form with both the concurrence with regards to the assault to if I give the transferred intent and adding some sort of descriptive language on the verdict form as to what the election is. So, moving on to count 2, I assume same argument. Count 3, I assume same argument. Have you guys had a chance to look at this, or do you need to look at it over the weekend and email me edits?
I think we should continue looking at it for as long as we have time in the courtroom, which I would say is 15 more minutes.
All right. So, let's, I guess there's 2 kind of overarching issues. Issue 1 is this notion that the defense wants an instruction about intending or knowingly using the paintball gun as a dangerous weapon. Does the state have any objection to that? Generally.
I see where that one is.
So, like, look at count 3, attempted assault in the 2nd degree.
Okay. That's fine. I mean, he admitted on cross that he knew that, so let's
Okay.
leave that in.
Well, and I actually do think, I can't remember if it was case law that I found or the case law that he cited or a combination of both, but it did seem like an accurate representation of the law. And so that kind of goes through anytime we talk about dangerous and deadly weapons, that sort of added he knew and intended it to be. I changed, frankly, a little bit the way that you wrote it up, Mr. Westover, to make it more consistent from one count to the other.
I think I was a little all over the place
Okay.
when I was doing it. So I'll review those and see if I
Okay.
have any additional.
All right, now, transferred intent. As I alluded to, I'll take a step back. I read Wesley last night, which was the case both parties cited in support of and opposition to the common law concept of transferred intent. Mr. Westover, without putting words in your mouth, I will say that you believe that the holding in Wesley allows for transferred intent only when the charge is murder.
Right, not just the holding in Wesley, but the lack of holding in any other Oregon case that suggests that transferred intent exists for any charge other than murder.
Okay. There's also no case that says it doesn't.
Right, and
Okay.
you apply the law, you don't make it here.
Sure. I think that transferred intent is a common law concept that does not necessarily only apply to murder. And in fact, transferred intent sometimes even applies in some civil matters. I did find case law on that.
It's almost entirely a civil. I mean, I agree 100% that in the law of battery, transferred intent is a thing. It is a civil principle.
I assume the state still wants transferred intent.
Yes, Your Honor. From the state's perspective, it's very straightforward. It is much like the fact that we have a case that says if you try to shoot one person and you kill another person standing behind him, it's almost exactly this scenario.
Right.
So
the intent follows the bullet / paintball.
Paintball.
Now, hang on. I do wonder if it applies to knowing intent versus intentionally intent.
If we want to limit it to that that it was for intentional, that's fine with the state.
And-
Just so you know, Judge, I am going to be contacting folks. This is a potential mandamus issue. I think that this is just dead wrong.
And we equally think this is dead right, and we've been arguing it, and we want this. So I know that council likes to interject this stuff, but I believe we should, proceed with instructions, and I request that it come in.
So my question is, in an effort to not confuse the jury, well, maybe take a step back. Are you saying you want me to instruct the jury that Alan Swinney intentionally or knowingly caused physical injury to Jason Britton, and then say that if you then put the transferred intent and then still keep the knowingly in there? Or should we, to make this a less confusing issue, remove knowingly from the elements in the definitions in this count?
I mean, they know they're gonna get reversed on this, they just wanna keep Mr. Swinney in jail,
Please, Mr. Westover.
as long as they can.
It's late in the day. Perhaps we should break for the day. I'm not going to sit here and listen to kind of the slanderous type stuff that's coming out.
Right. Mr. Swinney, we will see you on Monday morning. I'll have the parties back here at 8:30 so that we can continue this discussion. I will be willing to and anxiously wanting to get as much case law and parties' positions on these issues as possible between now and Monday morning so that we can be as efficient as possible. And obviously, all things can then be added to the record after,
And
Thank you,
Your Honor,
Honor.
would
Have
you
a
also
nice
accept case law or research on common law and what existed in Oregon common law?
I can think of no better way to spend a Sunday than
Right,
to read
thank
it
you.
all. I'll send you the latest version with the highlighting.
Yeah, anytime you see those lights on, the clock going on.
So we can turn off the record now. We can turn off the WebEx now. Have a great weekend, anyone.
Thank you.
Okay, yeah, they just turned the audio off, so, and there goes the video. So yeah, that's where we are looking at. Ugh, I was distracted, so I missed part of the discussions that were being had. Obviously, tensions are getting very frayed. Yeah, I think the slanderous type stuff was just Westover is like he's trying to assume that the jury's going to find him guilty and that it's only going to be because of things that Vasquez wants that are illegal. And it has been a very long week for everyone involved. They've been going all day every day. They've been working into the night. they're going to be working all weekend. This is, it's been 3 days of us sitting and watching. It's been weeks and months of work for them. So, yeah, that's where we're going to shut things down. I will try to work on. I just dropped in the YouTube chat the link that I have for documents regarding this trial. I will try to see about getting more stuff loaded into the database this weekend. I might also take a break and play some games. If I do, I'll probably turn the stream on just so that people can watch or chat, whatever. In the meantime, those who are able to be here Monday, great. I'll see you Monday. Those who aren't, follow us on social media. We'll try to keep you updated on what happens. Take care. Have a good weekend. Be safe. I'd say don't do anything I wouldn't do, but then we just have 70 people sitting with couch lock all weekend. So, peace. As far as following, in the link of the description of the link, there is a Linktree link that is kind of one of those aggregate things that has all of my social media, website, donation links. So all that stuff's kind of just in one place. As far as games, I do kind of boring stuff. Lately, I've been doing a lot of Surviving Mars and Minecraft stuff that's easy to just zone out with, or if I have to stop to look at something, it's easy enough for me to do. So.